As a legal community, we have serious concerns about sending people to offshore processing centres. We are concerned that this regime undermines international law conventions, such as the Refugee Convention and the Convention Against Torture. We are also concerned that the offshore processing regime undermines a core requirement of the rule of law, that is, of access to justice.
I'm Daniel Webb, the Director of Legal Advocacy at the Human Rights Law Centre. 267 incredibly vulnerable people face imminent removal to harm on Nauru or Manus Island. We're talking about 37 babies who were born here. We're talking about 54 children, many of whom are in classrooms around the country right now. We're talking about over a dozen women who've been sexually assaulted or sexually harassed on Nauru. Now our Prime Minister has a decision to make. He can either condemn these people to further suffering, or he can do the decent thing and agree to let them stay.
Hi, my name's Nicki Lees. I'm one of the social justice lawyers at Maurice Blackburn Lawyers. I initiated this joint letter from the legal community to call on Prime Minister Malcolm Turnbull to A, let the 267 individuals at risk of removal to Nauru stay, and also to end offshore processing as a policy of the Australian government. I did this because I have several clients that are involved in this and are at risk of being returned to Nauru, and I was shocked at hearing their stories and seeing just how terrified they were at the risk of being returned. It would be totally unacceptable for the Australian government to return them to countries where they suffered harm from, and we call on the Australian government to do the right thing and let them stay. We also believe that access to justice is a fundamental principle of the rule of law, which, as the letter shows, is clearly not being adhered to and being denied by sending asylum seekers to Nauru.
Why Australia is dealing with a country like Nauru is a very interesting question. Frankly, I think we ought to be a little bit more discerning about the countries with whom we deal, even if it's a shabby deal like imprisoning people who've arrived, innocent of any offence, arrived just looking for safety.
Hello, I'm Melinda Jackson, Chair of the Refugee Law Reform Committee at the Law Institute of Victoria and Principal Solicitor and Human Rights Law Program Manager at the Asylum Seeker Resource Centre in Melbourne. We believe, on behalf of the LIV, that the current system of refugee processing in Australia breaches our rule of law obligations in three important areas. Firstly, in regards to retrospective application of laws affecting refugees. Secondly, in relation to transfers within the detention network in Australia and to Christmas Island and offshore processing centres, which denies fundamental rights of access to justice and access to legal representation. And thirdly, in regards to the offshore detention regime itself, which the UNHCR believes breaches Australia's international law obligations, and we call on the Australian Government on behalf of the LIV to end offshore processing and to process asylum seekers efficiently and fairly in Australia.